I hope everybody had a good lunch. It's got some coffee. We have some more work to do and more interesting panelists. First, though, we'll hear from Sue Burrell, who's the Policy Director Emeritus at Pacific Juvenile Defender Center. Sue, Ms. Burrell, excuse me, will give a 5-minute presentation to the committee about an important pretrial issue that we don't discuss very much and doesn't get as much attention, which is judicial review of warrantless arrest for probable cause. After opening remarks, we'll have a few minutes for Q&A. Ms. Burrell?
Thank you. Thank you for inviting me. And I have to say, this morning's discussion was just amazing. It was just, I don't know who did the guest list, but all of the presenters were great. And I loved hearing all the judges talk about those issues. So thank you very much.
Thank you. Let me just give a shout out to our incredible staff, Tom, Rick, and Joy, who put together the panelists and our staff memo. So thank you. A lot of work went into it.
So my interest in what happens at the front end of cases really began when I was a young public defender in South Central LA in the early 1980s. And my clients that were in custody would be brought to court 3 to 5 days after they were arrested. And later, as a policy advocate, I was still interested in front end issues. And I wrote a law review article on the 48-hour rule as it pertains to juvenile cases. And then most recently, I helped to advocate for AB 2644, which now requires notification of the public defender or indigent defense provider for the county when a person is taken into custody. And so the presentations we've heard today have given us repeated examples of the importance of front-end protections to protect against racial injustice and a disparate impact on people that are poor. And I'll be talking about 2 very discrete issues in this regard where legislation would be helpful. The first is codification of the 48-hour rule in Riverside versus Mclaughlin. And the second, I'll just mention briefly, is extending to adults the requirement of notification of the indigent defense provider when a person is taken into custody. Just to set this into, to put it in context, Gerstein versus Pugh in 1975 said that the 4th Amendment requires a prompt judicial determination that probable cause exists to justify extended detention of a person without a warrant. And then in 1991, Riverside versus Mclaughlin said that prompt means within 48 hours. And it can be done as a paper review by a judge, or it can be, or a judicial magistrate, or as part of the initial court hearing. But Riverside was very clear that it has to happen in 48 hours with no extra time for weekends or holidays. And the Supreme Court specifically called out California's statute, which allows our arraignment statute, which allows extra time for weekends and holidays. And they specifically said that means that on Thanksgiving weekend, you could be held under the law for 7 days before the probable cause determination. But even though that case was decided 31 years ago, we've never changed our statute. And Penal Code Section 825, which is the closest we have to talking about this, specifically allows extra time for weekends and holidays. Plus, in the Welfare and Institutions Code governing juvenile cases, you get extra time for weekends and holidays, plus an extra court day to bring the young person to court. And there was a 1994 plurality California Supreme Court decision that allowed 72 hours in juvenile cases. But I think for a variety of reasons, I can't say in 5 minutes, I think it's unlikely that that decision would be made the same way today. There isn't much data on what's happening around the state. The Judicial Council doesn't collect this, the Department of Justice doesn't collect it, but I've done a little bit of research. In 2015, I sent a Public Records Act request to presiding juvenile court judges. And then earlier this year, when I got involved with this process, I surveyed adult defenders in the California Public Defenders Association. And the information from both of those efforts confirms that while many counties provide a paper review by a judicial magistrate, a considerable number, even of those, don't do it within 48 hours. Others perform the probable cause determination at the initial court hearing. And this means that people arrested on Thursday are brought to court 4 days later on Monday or even later. And responders confirmed what the Supreme Court spoke of in the Riverside case, that a person arrested on Wednesday before the Thanksgiving holiday could spend 5 to 7 days in custody before being brought to court. So this wasn't rigorous research. It was me with my Public Records Act request and a SurveyMonkey, but it suggests that compliance with the 48-hour rule is very uneven around the state, often because of reliance on our statutes. So the suggestion here is that we codify the holding in Riverside and in the Penal Code and in the Welfare and Institutions Code. And the outside limit should be set at 48 hours at a minimum. But the committee might also want to talk about a different time limit. In Riverside, Justice Scalia thought it should be 24 hours, and the American Bar Association has suggested that it should be 24 hours. And there's been a lot of talk about 24 hours in relation to other aspects of what we're talking about in the committee. And the committee might want to find a way to encourage weekend and holiday hearings. It could be through pilots. There could be some way to explore that as an option, because it seems like that's where we're eventually going to have to go. The second issue I want to highlight is immediate notification of the public defender when an adult is taken into custody. As I mentioned, we already have it for juveniles because of AB 2644 that just got signed in this last session. And the AB 2644 requires that the public defender or indigent defense provider be notified within 2 hours of the person being taken into custody. And this is so important, even if we haven't figured out the early appointment of counsel yet, just the notification would be so helpful in enabling defenders to do conflict checks and figure out who's going to be representing the person, getting either themselves or social workers in to talk to the person. There was that talk this morning about telling people that maybe they shouldn't pay the bail deposit for adults because there's a likelihood that either it would be the bail would be reduced or they might get out on OR if they could wait. And also information that's relevant to the custodial decision, information on the probable cause determination could be gathered, because sometimes there are gross mistakes about age or about whether the behavior was crime. And even whether charges or what charges are going to be filed. In juvenile, there's a huge decision about whether there's going to be a transfer case filed in serious cases. And if the public defender were on the spot earlier, they could maybe impact the filing decision. So I know that, that some of this has already been embodied in the staff recommendations, both on early representation and for your 2022 report. I think they're both really important issues that don't have a big cost and that we could do while we figure out what we're going to do about early representation. So I'll stop there and welcome any questions from the committee.
Thank you very much. Does anybody have a question? Just want to clarify. So we're talking about probable cause determinations, right? We're not talking, this is a separate issue from bail. And your suggestion is that the California enact a law at minimum that says probable cause determination must happen within 48 hours of arrest, period, regardless of Sunday, regardless of holidays.
Yes.
And this would be, is it now essentially done at the same time of arraignment?
It's in some counties, they do a paper review. There's a duty magistrate for the weekend. I think that was mentioned in one of the other hearings that you had. But in a significant number, they do the determination, as in Riverside versus Mclaughlin. They do it at the first hearing, and that is almost always longer than 48 hours.
Right. And we don't have data on whether how counties are complying, but at least your research shows a substantial non-compliance.
Yes, yes. Including, I might add, one person wrote in from Riverside County, an indigent provider there, and said that even there they follow PC 825 and give extra time for weekends and holidays.
Got it. All right. Thank you. Any questions from the committee? All right. Thank you. Oh, yes, Senator Skinner.
Whose responsibility would it be to enforce that? I mean, you were saying that basically, even with the law we have now, it's not really being followed. So I'm not exactly
Well,
sure.
I mean, defense counsel could enforce it through a writ. And I think, and there have been, I mean, I wrote some pleadings to help juvenile defenders raise it. It's one of those issues that's difficult to raise because the person is often out of custody by the time it gets to the courts. It has to be done very quickly because this is all within a period of days. And you could do appellate writs where the appellate court nonetheless will decide the issue because it's capable of repetition yet evading review. But it's tough to get, and we should, the Supreme Court already said your law is not right, and we should change it.
Thanks.
Thank you very much, Ms. Burrell. I appreciate it. It's good to see you. I'm going to move on to our next panel, and thank you again for being with us this afternoon.
Thank you.
Our next panel discussion will hear from practitioners across the state with their experience with bail and pretrial release. Our panelists are we ready for this, Tom?
Yeah, I'm promoting people now, so they'll start filing in. So,
all right. And apologies if I mispronounce anyone's name. Ryan Cousins, who's Assistant Chief Deputy District Attorney from Yolo County. Good to see you again. Tiffany Sina, I hope I'm pronouncing correctly, Supervising Public Defender from Sacramento County. Chief Probation Officer David Cook, I believe is how I pronounce it, Sonoma County. Bill Armstrong, President of the California Bail Agents Association. Jeff Clayton, Executive Director of the American Bail Coalition. And Gina Clayton, I assume no relation, Executive Director of the SE Justice Group. As usual, please keep your comments to 5 minutes or less. If you've submitted a written submission, we have read it. Please proceed to the high points. Mr. Cousins, we'd like to begin with you.
Thank you. And of course, I'm honored to appear in front of the committee. Thank you very much for having me again, Mr. Romano. So I didn't prepare a written submission in advance. I just have some comments on some things that have been said so far, and then I'd reserve my time for questions, at least from a prosecutor's perspective.
Perfect. Thank you.
For changes that could be made, I completely agree with most of the changes that were proposed so far. I think there is nothing wrong with having a 48-hour rule. I think if we're going to detain people, there'd be nothing wrong with having prosecutors show up on nights, weekends, holidays, whatever. That should be part of our job. Completely agree with that. Completely agree with the immediate appointment of public defenders in cases as previously raised to help make sure that detainees' issues are being raised. Pretrial release programs. Our county has had a pretrial release program for years. I know that's part of a pilot project now. I think every county should have them. I think that they're incredibly valuable. We have 220 people right now on a supervised own recognizance release. We generally supervise between 200 and 400 in a county of 250,000. Most of our detainees are released on straight OR at the time of arraignment. There was an issue raised on electronic monitoring previously, and I wanted to offer a clarification because I read the written materials as well, and there were discussions about not being able to go to doctor's appointments or go to job interviews and such. And I think that there was a mixing together of home detention as part of a sentence, which we do frequently on electronic monitoring in our county, which does have restrictions on where you can go versus pre-trial electronic monitoring, like on GPS, where for that, at least in our county, and I confirm with our probation chief that he's not aware of other counties, counties that do differently. There's not real restrictions on where you can go, at least within the county. You can go to your doctor's appointments, to your job, whatever. We had a doctor on monitoring that ran a marathon. I mean, we don't put restrictions on that, and we also pay for it. So there's not that, at least for our county, there's not that.
Hey, Bill, it's Tom.
That monetary.
I'm having some trouble making you.
Wait, Tom, you're on, there you go.
There's not, so at least there's not that monetary consideration. So I do think there's been a mixing of two different types of monitoring, and the pre-trial GPS is much different. And obviously it gives victims some sense that somebody's movements are being monitored, particularly in domestic violence cases, stalking cases. But that's a program that's very robust in our county, and we support it. I think every county would benefit from having that in place. And then also the codification of Humphrey. I was involved in SB 10. I offered edits and review of different things and drafts and all that. And I followed SB 262 through its iterations. And I know at the very, very end of the process with SB 262, there was an effort to perhaps codify Humphrey. And I do think that's valuable. And I think we should just focus on that principle holding from Humphrey, which is an arrestee may not be held in custody pending trial unless the court has made an individualized determination of having the ability to pay but not paying, or detention is necessary to protect victim or public safety or ensure the defendant's appearance, and there's clear and convincing evidence that there's no least restrictive means available. And I think those four things, like don't offend what was established by Proposition 25, there are ways of addressing the concerns regarding bail. I sent Tom a policy that we adopted in our own office that has a lot of presumptions for not asking for bail in our county, with exceptions. A DDA shall not seek bail if the defendant has no pending criminal cases, has no outstanding warrants, is not currently on probation or parole, is not required to register, has not willfully failed to appear in the present case, and is not currently on post-release community supervision. That's even for serious crimes, statutory serious. We carve out exceptions for violence, escapes from custody, fugitive complaints, things that you'd reasonably say, okay, bail should be looked at. Somebody having a demonstrated pattern of non-appearance, and we actually describe what that is. It's a certain number of FTAs within a certain period. So it's not just missing one court date where there's an excuse. There's this actual pattern that shows that somebody has difficulty showing up to court. A final thing I'd say is in looking at all, it's hard to have a conversation about the bail statutes and what should be done outside of the context of a particular statute, because they're so nuanced and so many things could be said about them. But I know there was a statement made earlier about people liking the Illinois statute. The Illinois statute, for reference, is 725 ILCS 5/110. I can put that in the chat. It's awful for a number of ways. It's full of contradictory statements, like defendants shall be detained if they're a flight risk, but then it changes the analysis 5 pages later, saying that they will be released absent certain circumstances. It kind of has some problems that have showed up in other drafts and iterations of bail reforms, which is it creates this super heightened burden on public safety. And with the Illinois statute, what it says is you're required to do release, at least on a public safety standpoint, unless you can show a present, immediate, specific threat against a person, which in judge terms basically translates to a hit list in the person's pocket. to where even if somebody presented an extreme public safety risk or even random towards a number of people, they would be released. And as far as failures to appear, it says in the beginning you're to consider flight
Wait,
risk.
I'm sorry. I'm sorry to cut you off. I do want to get to everybody, but whether or not the Illinois law is a good model or not, I don't want to get too far in the weeds on it. I hear that you have some exceptions to it, especially in the details. We're going to get to comparison with other states in our next panel, but and we'll reach back out to you. But I do want to make sure that we have enough time for everyone. And so I don't want to get too far down in Illinois. Is there any last comments that you want to make before we move on?
No, that's it. I'm happy to. I guess, yeah, a last comment is I think we need to be very concerned in crafting bail laws that we don't let the already out of control FTAs in the different counties get even worse. We track 10,000 people in warrant status in any given time. In the last 6-month period, we had almost 3,000 failures to appear. And I think we need to be careful when we address bail with changes that we don't make those problems worse, because there can be no process that proceeds forward unless the person's in court.
Got it. Thank you very much. Ms. Sina, is that how you pronounce your name?
Sinnott, thank you.
Sinnott, excuse me.
I'm Tiffany Leanne Sinnott. I'm honored to be here. Thank you for the opportunity. I am a public defender. I've been a public defender for 21 years. To kind of set this context of my lens, I just wanted to paint a picture of what happens every day in Sacramento County. We have about 150 people arrested. They are handcuffed. They are thrown in a police car. They are transported to the main jail and booked into custody. They are then transported or sent to their cell, where they sit in their cell for about 3 days. And during that time, if they're indigent and they can't afford an attorney, they sit in that cell and wait for this big arraignment day where they're going to get appointed a public defender and what they believe will be an opportunity to finally be heard about getting out of custody. And so after sitting in custody 3 days, dealing with all the trauma of being arrested and removed from their community, they show up to court, and they are brought into court in a giant human cage where they stand before you, and the judge asks if they can afford an attorney or if they want one appointed. If they say they want a public defender and they can't afford an attorney, they're given a public defender right there on the spot. And we have about 5 seconds to look at our client and say, "Hey, I'm Tiffany. I'm your public defender. How can I help you?" And they panic and they start telling you as quickly as they can why they have to be released out of custody, and how they have kids at home, and how they have medical issues, and on and on and on. And as a public defender, you do your best to listen to them and then turn to the court with just a few moments and explain to the court and the district attorney why this individual needs to be released. And if you need time for more productive quality bail hearing, the case gets put over for 2 days. We have to do better. What happens in Sacramento County happens across the state. And this is how arraignments are done. And this is especially how it's done for individuals that can't afford that private attorney that goes to see them in custody prior to that arraignment. And so that is the lens my recommendations are made to you. In 2020, as a public defender, I decided that there has to be a better way. So I worked together with my office creating a pretrial support project. There's nothing about this project that's rocket science. It's a program that can be implemented across the state. The real secret sauce to this program is that public defenders have access to their clients prior to that arraignment. It allows us to go into custody, meet the client, get all that information that we need. We also conduct 4 evidence-based tools when we meet with the clients, so that we're not only finding out what our district attorneys may want to know is, hey, do they have a residence? Are they housed? Do they have employment? But we also find out what is going on with their mental health status. What's going on with their substance abuse? What's going on with their trauma? What is their underlying trauma? We gather that information. We have a team of social workers that help us with coordinating a case plan. We have a contract with the community organization that provides immediate mentorship. So then when we go to court, we're able to tell the judge everything they need to know, and the district attorney. We have to do better for our district attorneys in the bench. We can't put them in a position where they're trying to make decisions and they're not given the information that they need to make the decisions. That's what this program does. It allows the district attorney and the court to have the information they need to make decisions. The success of this program I spoke to in the brief I provided. But I think the biggest success is that you're taking an opportunity for the state to deal with so many other issues. You're not just releasing an individual, but you're taking an opportunity to address mental health, unhoused issues. And so you can really stop that revolving door of individuals coming in and out of custody. The other recommendations that I would make include that we modify notification standards to the public defender and the indigent providers, just like we did with the juvenile law that was signed, that Sue just spoke to, AB 2644. If we're doing with juveniles, we should do it with adults. Notify your public defender that somebody's been booked into custody. Also provide access to public defenders prior to arraignment. I'd also recommend that we strike speculative language in the provision code. It is really unfair for our bench to have to make a decision whether or not somebody is a potential danger. Anybody's a potential danger. The language we should use should not be speculative. We don't allow speculative language as evidence. We shouldn't be making a decision regarding release based on speculation. Striking that language, are they a present danger, would make a huge difference in the way bail hearings are conducted. I'd also recommend that we compel a willful finding of failures to appear, because what happens in court is the district attorney just counts out the number of failures to appear, but nobody knows whether or not they were willful failures to appear. The law is willful failure, but it's not anywhere in the code. Also, the current provision of the Penal Code requires, as one of the considerations for the court to consider, is proof of residence beyond a verified legal address of 1 year. With COVID, we are seeing people have multiple different residences, not just a verified address of 1 year. It also completely excludes our unhoused population who can't speak to a verified residence of 1 year.
All right, I want to, can you just wrap it up real quick? Because I want to make sure we get to everybody.
Sure. I would also just make sure that the code includes Henry Humphreys, Stack v. Boyle, list alternatives to incarceration that can be considered, and the collateral consequences of detention.
All right, thank you. I'm sure we'll get back to a bunch of that. Chief Cook, is that how you pronounce your name?
It is. Thank you.
Nice to meet you.
You as well. Thank you, Chair Romano, members of the committee. I'm pleased to be here today to discuss this topic. Probation departments have been operating pretrial programs for several years, longer in some counties, and many of these programs were in place prior to the Humphrey decision. Since that decision, though, probation agencies have continued working closely with the courts and all stakeholders to implement requirements in Humphrey. Pretrial programs are an integral component to implementing the Humphrey decision, and that calls for courts to consider whether non-financial conditions will reasonably protect the safety of the public or the victim and assure future court appearances. They also highlight the importance of risk-based decision-making. Validated pretrial risk assessment tools are in use today. Importantly, pretrial programs center around the tenets of maximizing return to court while maintaining community safety. We believe equity and safety are both integral components to maximizing the safe return to court. Pretrial programs can offer a continuum of non-financial responses that include court reminders and check-ins, linkages to services, and monitoring depending on risk and related factors. These are all in place today. During the pretrial pilot program, probation agencies were conducting assessments prior to first appearance and providing information to the courts, which facilitated the option of early release. In many counties, this practice is continuing. As well, throughout the pandemic, when the emergency bail schedule was implemented, many probation agencies experienced an increase in the number of individuals released to pretrial. In Sonoma County, The number of people released to pretrial almost doubled during that time, with little to no increase in the incidence of new criminal activity or failure to appear. In relation to probation's work with the courts, probation serves the court as a neutral party. We're accountable to the courts and the public to provide information to judicial officers prior to arraignment or earlier to assist in maximizing the safe release of defendants. In doing so, probation does a number of things. We provide important information to the courts in making pretrial determinations, such as conducting interviews and gathering background information, including assessment of a defendant's financial circumstances, assessing risk factors, in essence, community and victim safety, as well as likelihood of failure to appear for a court hearing, assessing defendants' needs for services, providing the court sufficient information to make a decision regarding release or continued detention, and collecting data and systematically reporting that data to the Judicial Council to assess the impact of risk assessments, release decisions, and pretrial services on defendants. And then finally, I would add, research has demonstrated that pretrial services are most effective when these components are part of a pretrial program framework, much like what most probation agencies have adopted and put in place currently. And with that, I'm happy to take any questions that committee may have.
Thank you. I'm sure we'll have several for you. Mr. Armstrong. Are you there?
Yes.
We can hear you. We can't see you, which is fine if you don't have a camera, but if you have 5 minutes, we'd love to hear from you.
Yes, thank you. Coming back from the convention. So I did submit a paper. And, I hear most of the panelists that are talking about things. I'm coming from a bail point of view. And, most of the work that we do is well in front of all of this. Often we are talking about bailing people out within an hour, two after their arrest. Basically, they just have to get processed. It's a decision they can make. And we try to do this as quickly as possible. Our feelings is that, bail is a great benefit to the defendant because one, it's voluntary, two, it's extremely fast, and delays are good for defendants. When we bail people out, one of the first things that comes along with that is a delay. It often gives a district attorney time to look at the case and so on before they file the case. And I often tell my clients, look, we're getting you out of jail right away, save your job, whatever. But the reality is that delay is probably the most important thing as a part of the process, because you now have time to reset, figure this out, figure out what you're going to do, how you're going to handle it, and so on. In my letter to you, it talks about the Humphrey's decision on a transfer after this time, that Humphrey's is supposed to take a look at whether or not you have the ability to pay, whether or not it's appropriate to set bail. And but that comes mostly after bondsmen are involved. Obviously, we can write bail after Humphrey's, but it was an attempt to put to make it fair to people. The bail schedules are set by the crime. They're not a factor of race or color or anything. They are strictly based on the crime that was committed, and that's very fair in my opinion. So really are reacting to things long in front of a lot of the panelists are talking about things that are quite a ways down the road on how we handle bail in California. You know, there's been pretrial has been in handled by probation long before these things. So we're happy to entertain anything, but I have my other panelists, Jeff Clayton, that'll probably be more specific on things. And I'd like to defer to that.
Well, thank you. I'm sure we'll have questions for you. I really appreciate you calling in. Mr. Clayton?
Thank you for the opportunity to appear. I'll just hit a couple of high points. I'll start with unsecured bails. I mean, obviously, I cite the BJS statistics that show that unsecured bails perform worse than releases on unrecognizance. So if we can say this group of people should get an unsecured bond, they should actually get a release on their own recognizance. The citation to the Mike Jones study, I mean, I'm from Jefferson County, Colorado. I was there. I know all the county officials involved when that study happened, but the problem with that is that the Jefferson County officials abandoned the program because it didn't work. And they sent a letter to the Maryland Court of Appeals to that effect when Maryland was looking at going to unsecured bails. The other problem with the study is that it's premised on the outcome of the CPAT tool, which is the Colorado Risk Assessment tool, which the ACLU found was fatally infected with bias. So the results are based on a flawed instrument. The other thing in Colorado that's different from California is all what we call PR bonds have an unsecured amount set. So it's just really hard to compare that study. The other thing I'll point out is in Philadelphia, who went down this road some years ago, was owed over $1 billion and eventually disbanded their program. I also feel that unsecured bonds are dishonest to the public. I mean, the newspaper will report that there was an amount of bonds set by a judge that was posted by a defendant, when in fact that was not the case. The other issues are turning the state into a bail collection agency, and around the country we just see that these amounts are never collected. The other thing that we've noticed is that they eliminate the incentives to return because defendants are afraid they're going to forfeit when they show back up. They think they're going to have to pay when we all know they're not going to have to pay because the state's never going to collect it. So in essence, it creates a disincentive to return when you failed. To talk a little bit about partial security, which we would call 10% to the court. The BJS study found the same thing, that partially secured bonds perform equally as well as releases on unrecognizance. So same argument is if we can identify these people as deserving of the 10%, they should just get out on their own recognizance, which would be something we would support. 10% is ripe for abuse. If you go down to St. Louis, what happens is the attorneys lien the client's funds and the judges play along with it. And so they use it as a mechanism to pay attorneys as a way to avoid having to fund the public defender service. It's also used as a collection mechanism in many states. Indiana funds largely its court system off of this, but other states, it's fines, fees, costs, restitution, and surcharges that are collected, and 10% is the target. When the cash is handed to the government, it's too hard for them to give it back. The other thing is laundering. What ends up happening is that the jail has to accept cash, and their mechanism to accept cash is to put it under the inmate's canteen account, which essentially means the third parties, which 90 to 95% of the time are providing the money to post the bail, actually forfeit their right to the money, which is then used for fines, fees, costs, restitution, surcharges, et cetera. The other thing I'll notice is that there's a footnote in the staff analysis about the 1979 Bail Reform Act, but that was allowed to sunset in 1984. And I was one of the oldest bail agents in California sent me a report this morning from 1983, sort of detailing why it was a failure. So I don't think partial secured and unsecured is the way to go. I think it's a question of bail and release. And obviously the thrust here is for more OR releases, which is fine. And I think if we can highlight people who are eligible for ORs, that's where we should go. Let me talk a little bit about Humphrey. I think, I drafted an amendment to Senate Bill 262, which was referred to. And my concept is not to codify Humphrey, it's to define the contours of the hearing. That's what we failed to do. When is the most important question, because if you look at the penal code, there's no answer. Justice Cuellar invites us to put a limit on it, and we have not done so. The state of Florida does all this in 24 hours, okay? So you get a robust, meaningful hearing on bail in 24 hours. In New York, you get to do de novo hearing, meaning in front of a different judge, you get to retry bail, because that's the whole point, is how damaging it is when people stay in jail when they shouldn't be there. So what does it really mean across the nation? Meaningful opportunity to be heard. What does that mean? Do you get an attorney? Can you present evidence? All that sort of thing. Can it be de novo? And the heightened standard, as the district attorney pointed out, is already in the case, the Humphrey case itself. So I worked on this for 7 years, and I can tell you little jurisdictions like Ascension Parish, Louisiana, Dothan, Georgia, Calhoun, Georgia, the city of Dodge City, Kansas, which I flew to work on their procedures, were able to figure this out. So I'll send you the amendment I drafted, but I don't think it's as hard as we think it is, and it's critical. And is it going to cost money? As I point out, it is, but we need to spend the money on this. Okay. And so we are completely in favor of that. So I think at the end of the day, and what I've heard and what I've seen in California is inadequate due process, administrative delays. And we have got to get to that. And we can talk all we want about affordability and all this sort of thing, but if we can't get people in front of judges to make the arguments, why are we here? And when I was an attorney, I never even cared or even worried about bail. We just called Joe Beanie the bail bondsman. But you know what? In 2022, it's just not good enough. We should be talking about how many hours you have to sit to get a bail review hearing, not how many days. So thank the committee for their time, and I appreciate the work of the staff, and thank you very much.
Thank you. Ms. Clayton Johnson.
Good afternoon, distinguished committee and Chair Romano. My name is Gina Clayton Johnson, and I'm the founder and executive director of SE Justice Group. SE is the country's leading organization of women with incarcerated loved ones. We are community organizers. We break isolation and develop the leadership of mothers, sisters, wives, aunties, and grandmothers of people behind bars. In other words, the women who are the reentry system of this country and the people who pay or try to pay the bail. We are founding members of the National Bailout Collective, original co-sponsors of SB 10, on the executive committee of Justice LA, co-drafters of the Preserving the Presumption of Innocence and Due Process for Pretrial Incarceration Act, and I'm a member of the policy table leadership for the Movement for Black Lives. In a prior life, I practiced law at a community-based public defender's office in Harlem. I'm grateful for this chance to speak with you today. I'm first going to situate our work and perspective within the history of SB 10, and then I plan to share some impacts of money bail on women. We were one of the 7 co-sponsoring organizations that kicked off the campaign to end cash bail in our state, joining Senator Hertzberg and then Assembly Member Bonta to introduce SB 10 and AB 42. We and the Silicon Valley Debug were the leaders in organizing over 30 directly impacted groups in a coalition across the state to develop the momentum and community support for this bill. The bill wasn't perfect, but we knew it was something that would go a long way. Ultimately, we opposed SB 10, and here is why. In the 11th hour, the bill was changed to create a rebuttable presumption of detention for certain individuals charged with certain crimes. The new procedural additions opened up avenues to more incarceration, not less. Indeed, this is why Prop 25 was not defeated. We were disinterested in waging the ground game that could have taken it out because of how SB 10 had changed. I want this committee to be aware of this history because bail is a live wire for directly impacted people and communities, and reforms that simply eliminate the industry without ensuring that increased access to pretrial liberty is achieved are not tenable. Bail reform is also a race and a gender justice issue because it is causing harm to the financial, socio-emotional, and physical well-being of women. Women make up more than 80% of family members primarily responsible for covering court-related costs. And the average family amasses over $13,000 in debt due to legal fees and fines. In a report we published surveying over 3,000 women, nearly 50% of women with incarcerated loved ones who have owed money to private for-profit bail bonds agencies have faced housing insecurity. 35% of women we surveyed noted experiencing homelessness, eviction, or the inability to pay rent or mortgage on time as a result of their loved one's incarceration. The impact of bail on Black women is exacerbated by the fact that bail amounts are 35% higher for Black men compared to white men. Yesterday, I sat in person with 12 women who had set aside time after I told them I was speaking with you today. They included 3 formerly incarcerated women, one woman who we just bailed out in April from Linwood Women's Jail in Los Angeles, and they were all women with incarcerated loved ones. And I asked them, what is it that you want this committee to know? In a tear-filled conversation, they shared their stories of exploitation at the hands of a predatory industry, of the connections between children ending up in foster care because of a parent's pretrial incarceration, and other terrible consequences that mass pretrial incarceration has caused. The woman in that circle who we bailed out was in on $200,000, an amount the judge had good reason to know that she could not afford. She was incarcerated from January until April, and in that time, she lost her children. Yesterday, I presented her with a certificate of completion in a rigorous training program we run. She has weekly check-ins with a member of our organization who she asked to be her AA sponsor. She has a part-time job, a place to live, and is in therapy. Were she have been released into the hands of probation rather than a community-based organization, my experience tells me that the results would have been very different. There are many recommendations that we are aligned with. In particular, some of those that Tiffany Lance Senate presented and that Vera presented earlier this morning and will again be presenting later this afternoon. I'm probably at time, so in the Q&A, I'm happy to speak to recommendations that I'm prepared to offer. So I hope you asked me about it. That's kind of what I'm saying. A brand new one that came out of our organizing and listening to directly impacted California women at the pleasure of this committee. Thank you.
Okay, thank you. What a great transition. Here you go. What's your brand new idea?
It worked. Thank you for the question. The idea is that this committee consider requiring that any pretrial services be separated from entities responsible for the management of people who are post-conviction. We recommend that the penal code make clear that the constitutional protection against sentencing without due process means that punitive corrective agencies may not be involved in pretrial processes whatsoever. We also suggest making an exception, saying that punitive agencies may not be involved unless there is an individualized on-the-record determination by a judge that involvement of a punitive or corrective agency is required to safeguard against a substantial likelihood of bodily harm to others. We also recommend defining punishment in the penal code as including fees and fines, probation, supervision, or incarceration.
Okay, thank you. So there's a lot to get to. Thank you all, really, and there's a wide spectrum there. Do any committee members have questions as we start off a Q&A? All right, I'll start, but I really do hope everybody else jump in. Chief Cook, I think that last comment was directed largely at probation. I know that probation offices around the state often take on this role of for providing pretrial services. I know other counties do it differently. I think we heard earlier today that even sheriff in some counties may offer pretrial services. Do you, first of all, I know that you described probation offices as being neutral, and I think that there are some who might feel differently. But as an initial question, do you think that this is exclusively the province of probation offices, or should counties be able to contract with third parties or even sheriffs or I suppose public defender's offices? Or do you really think that pretrial services should be housed at probation offices?
Thank you, Chair Romano. With respect to probation, I know that Santa Clara County has operated an independent organization that covers pretrial for many, many years, and it's been successful. Probation was tasked with in the pretrial pilot program. And because we're uniquely situated in the criminal justice system, as I indicated, a neutral party, neutral arm of the court, and our experience in conducting risk assessments, which I believe in, despite some flaws, and those are being corrected to account for bias and overcome that. I think we are well positioned to carry out the fundamental premises of what pretrial should be. We are familiar to the court, the district attorney, the public defender, and we have access to the jail. We can get in to see clients and individuals who are pending in the system. And we have been able to shift thinking in terms of providing monitoring of defendants released to pretrial versus supervision. And I know that's a nuanced clarification, but I believe we are uniquely situated and capable of handling this responsibility.
So are you saying that other agencies or organizations should not be responsible? I understand that how probation might be useful, and I heard your argument, but as you know, in other counties, it's handled differently.
Yeah, that'd be something for the legislature, I think, and the courts to decide whether or not it ought to be probation exclusive, or if other entities could in fact carry out those responsibilities.
Got it. Mr. Cousins, do you agree with Ms. Sennett? Is that how you pronounce your name, Ms. Sennett? That willful failure to appear, I think Ms. Sennett said that that's the law, but not in the code. And you had warned us about the failure to appear issue. It would seem that willful fail, that would be an important distinction. Do you agree that that's the law, but not in the code? Do you know what she's getting at?
Well, yes, to prove a failure to appear as a crime, you have to show that it's a willful failure to appear, among other things. But I'm not sure that should be the standard for deciding whether or not somebody should be detained. And I just for a perspective, when we have in our county somebody failure to appear, very, very often their attorney will say, give me a chance to put this out 2 weeks and let me try and contact my client and bring him in. And we do that. And I'd like to think that most prosecutors' offices are like that. We did it 821 times in the last 6 months. We give them a chance to try and get a hold of their client, they bring them in, because sometimes there is a good reason why they failed to appear, but there's a difference between not showing up on that day, and late is not failure to appear. I saw that somewhere in the written materials. That's absolutely not true from our perspective. We wait all the time for people to show up. But then when they don't call their attorney, they don't get in touch with them for days and weeks, at that point, you can infer that it's willful. Or if there's a history of 10 failures to appear, you can infer that like at least some of that is willful.
And just to clarify, this is not, you're talking about when you're measuring somebody's, whether or not we should detain them pre-trial.
Yes, both in the context of the initial and then what happens when somebody's coming along and then they just fail to appear. Most of the time we say, let's put it out 2 weeks to see if the attorney can get their client in, and the public defender asks for that, and we get that. I can't speak that that's the case in every county, but that is one tenet that I've noticed in a lot of the bail reforms, is that the reform is asking for this heightened standard, and with our bail
heightened standard for what? I'm sorry.
Heightened standard for failure to appear that involves some element of like maliciousness or willfulness that has to be proven before they can be retained, when there's enough evidence in the record from which you can infer it. Ms. Sennett talked about the DA just reading off the number of FTAs. And the reason why we do that is because, again, if somebody has 10 failures to appear in 2 years, you can infer that they don't care about coming to court, or that there's an element of willfulness there. That may not be the case, but I mean, under ordinary circumstances, if somebody's doing the same thing over and over again, I think it's a justifiable inference that they're avoiding coming in. And oftentimes, and I've certainly done it, when somebody comes in and they say, hey, I was in the hospital, here's my records. If they were in custody, I ask that they be let out. So, I mean, if they come up with something, and again, we're not talking one failure to appear, we're talking several, and again, it's the failure to appear problem is just, it's a real problem.
Understood. I'm curious, just staying with you, Mr. Cousins, for a minute. You mentioned a couple of different, we'll call them reforms that your office has undertaken for the, would you categorize them as that?
Yes.
Have you tracked how that's impacted the jail population and who is being held pre-trial?
I haven't drawn, no, not that particular nexus. We have the data, we have tons and tons and tons of raw data, but not that particular nexus. Well, I just checked this morning. We actually have the same level of people in our jail, 244 that we had during COVID. So it hasn't, there was a big release and then it hasn't changed.
And when did these reforms go into effect? Just so
this particular, like the reform that we did for our bail, which by the way we have to show a concerted effort to avoid prosecution under our policy. Like it's not just one FTA, it has to be several within a course of a certain time period. So I'm not saying FTAs should be immediately bring the hammer down. We have like an actual standard. That was November of 2021. We did it before the vote on Proposition 25.
So mid-COVID is when you're saying that the
Yes.
jail levels have remained low.
Jail levels have remained. I can't speak to their total possible population, but yeah, there's only 244 people in the jail currently.
All right. So, and it seems your anecdotal experience, it seems to say that these policies are letting people out more often. Is that what you're trying? I'm just trying.
Yes, I mean, the DA is required that unless we can show those certain things, that we have to ask for
No,
for
I
bail to not be
appreciate that. I
set.
just want to see to make sure it's reflected in the data.
Yeah.
Which would make sense. And it all makes sense. I just want to understand.
Yeah.
Other questions?
Chair, is it okay if I chime in with a
Yeah,
follow-up?
if you would, and then I was going to go back to Chief Cook. Go ahead.
I just want to emphasize that because the questions you asked probation, Judicial Council did give the Public Defender's Office funding out of SB 10 to have the program that we're supporting, largely because a risk assessment number of 1 through 6 doesn't tell you whether the person's employed or has kids or what the collateral consequences of incarceration is. So I think having holistic defense approach, you have to protect against self-incrimination. You can't have law enforcement or probation interviewing clients about whether they have a drug history, whether they have mental health histories. It does then violate self-incrimination issues with the pending case.
I got it. I do, before getting to Chief Cook, you had mentioned about this pilot that you had initiated. And I guess my question is, is there a statute that's stopping public defenders from doing this? Or is it just resources and energy and money, candidly, stopping this from happening elsewhere?
So we have a charter in Sacramento County, which says that we are appointed on all cases. Not every county has a charter like that. I think that's number one. Number two, the sharing of information if the individual is booked into custody. Our sheriff's department was really collaborative with us and made that happen. Other counties don't have the ability to have access to who's being booked in custody and when.
Okay, so we've heard this before, and this seems pretty elemental to me and non-controversial, that public defenders and indigent defense bars or panels should be notified immediately or as quickly as possible that somebody's been arrested. You think that would do the trick or would be a significant improvement in the system?
I think that's a significant improvement. I also think, public defenders need resources to go in and interview individuals to conduct the appropriate scope of investigation needed to present a bail hearing and to meet the standard of Humphreys.
Now, I'm just to clarify again, and then I actually have a question for Mr. Armstrong too. A bail hearing, you're envisioning, even an ideal circumstance, right? You're notified right away in your program. When does the bail hearing happen if somebody who's enrolled in your program? It's still how long after arrest?
An ideal situation, you'd have your bail hearing at arraignment.
That's 48 hours.
Was within 48 hours.
Yeah, I mean, and I know it's within 48 hours, but is that generally the rule?
Generally the rule,
Yeah.
right? I mean, in the perfect situation, I'd have a presumption of release, right? And
Right, but I'm just talking about how under the current system, you would be in there and 48 hours later, we'd have an arraignment and we'd have a bail hearing. Mr. Armstrong, are you still there?
Yes, I am.
Correct me if I'm wrong, and Mr. Clayton or anybody else can chime in. I believe what we had heard earlier, and I believe what you were saying was that almost everybody who bails out, at least using money bail, does so prior to the arraignment. Is that what you were getting at?
Absolutely.
So the system that Ms. Sennett is describing really wouldn't affect the money bail
Well,
situation.
we will write bonds after arraignment, but generally speaking, most bail is conducted prior to arraignment. And the greatest benefit is because of that fact that it's so fast. And, preset bail schedules are very fair because they're based on crime, the charge. They're not based on other factors. They are strictly based on the charge. So we're involved at a very early stage in the arrest process. Usually within an hour or two. A lot of times I'm getting calls that are coming in, an hour after the defendant gets to the jail.
Can you rough estimate what percentage of bail, I don't know if you can say for all of California, as post arraignment? Are we talking about like tiny amounts? Go ahead.
I don't have an exact figure on that, but my experience has been a very high percentage of people calling immediately, because the great majority of bail that we deal with are not, career criminals. These are people that get in trouble, whatever reason, once, twice in a lifetime. And we're there to help those people and write those bonds and to get them out at a very fast rate. I mean, it happens almost immediately.
I appreciate. Sorry to interrupt. I appreciate that. It just seems that I'm trying to isolate two different issues here, which are what I'll call, for lack of a better umbrella, the Humphrey issues and that happened at arraignment and afterwards, and that which happens before arraignment, and a lot of concerns about money bail appear to be, and I'm going to go to you, Mr. Clayton, that the vast majority of money bail happens pre-arraignment. Are you agreeing in that, at least in California?
Oh yeah, at least in California, that's exactly right. And that's exactly what the issue has been around the country with bail schedules is, you don't want to set them all, because then you got to have judges and have a hearing on all of them. So you're just trying to get, as many pathways out as you can, as fast as you can, and then to have, a robust review process afterwards. And that's kind of what we've been working on for the last 7 years in other states.
And just so we get some estimate of what's vast majority, I won't really hold it to you in any court of law, but is it 90% is pre-arraignment? Is that what we're talking about? Or is it when you say majority is pre-arraignment?
Bill?
I would say yes.
90%. Does that sound fair to you?
It's very high. I don't know the exact amount.
No, I appreciate it. I'm asking you for data that you don't have, but I just want to try to get a picture of it because this isn't my expertise. Is that seem reasonable to you, Mr. Clayton?
Yeah, I mean, I've heard it could vary a lot jurisdiction, but 75% maybe is a good number. I don't know,
All right.
but it's high.
Okay, a large majority. Ms. Sennett, just talk to you. Yep. Ms. Sennett. So the issues you're talking about, though, won't really capture the concerns that people have about money bail, right? Am I right to say that your focus is primarily, is your experience also that the vast majority of people would bail, who do make bail, do so before you really?
people that can do. The problem is equal protection, right? So the indigent individuals that can't afford bail remain in custody and they have to wait for their arraignment and a bail hearing. So yes, the people that can afford bail, they will get out of custody, they will get back to their families and their jobs. But the people that can't afford it remain in custody until that hearing.
Right, okay, that makes sense.
Mike, I have a comment. Were you getting at the question of, let's say there are 100 custody arrests, people taken into custody. How many will be bailed out? How many will be cited out following a brief amount of time in custody? And how many will be arraigned? Is that what you were kind of trying to get kind of in the scheme of things of those who are actually arrested? How many actually are in custody at the time of arraignment?
I was asking a slightly different question, but I do believe, and Tom, maybe you can jump in here, that a partial answer to your question is in our memo. And I think if I'm reading things right, according to limited data that's available, between 60 to +% of all arrestees are released either on OR, bail, or cite and release within the first 48 hours. Is that right, Tom? Can you summarize that?
That's right. That's what the Judicial Council has reported. Yep.
Okay. So we're really looking at also at the 40% who are still in custody at time of arraignment.
Well, there's two groups.
Yeah.
There's this 40% at the time of arraignment, and those we'll say are Humphrey related issues. And then there's the pre-arraignment, which is mostly the money bail area.
Yeah, right.
Not to overgeneralize. Is that fair? Okay, everybody's nodding. Good.
Mr. Romano, if I may,
Yes,
on that
please.
timing issue, I did want to add that although you do have this setting of bail at the arraignment, that hearing, under the penal code, you're entitled to a separate automatic review of any bail amount being set. It's penal code section 1270.2. So there is this automatic review process built in.
And that's before the arraignment in court?
That's after, it says when a person is detained in custody prior to conviction, that person is entitled to an automatic review of the order fixing the amount of bail. So that would be the amount of bail set at arraignment, assuming they were arraigned on that date and bail is set.
Yeah.
So you do get a review, an automatic review date.
Right. You know, I remember a classmate in law school as a job was stationed at the jail, and he was doing bail review. Now, I don't know who he was working for, but he would be able kind of to set bail. Does that kind of thing still exist? This is when people are just right in custody within a matter of hours. He would do the bail review and maybe run it by a judge. I don't know.
Well, if we have a warrant, or I think it was alluded to earlier in the panel, if there's an arrest made and the officer makes an application for bail, we have a very, very low bail schedule in Yolo County. It's a fraction. You know, I think a stalking bail in our county is 20,000, whereas in just about every other county, it's 100, for example. But there's latitude to go to the judge and ask for it to be increased. But then otherwise the jail is just looking at a schedule prior to arraignment and then setting it. And then the judge reviews it at arraignment. But there are certain limitations, because at arraignment, for example, if it's a strike being alleged, the code says you have to follow the presumptive bail schedule unless there's reasons to deviate, for example, and there is other limitations.
Mr. Cousins, do you have a site? Can you describe cite and release in Yolo County? How it works?
I'm not sure if I'm using the same vernacular as you do. I mean, we certainly write, tickets for misdemeanors. I'm not sorry.
So my understanding is, and maybe Ms. Sinnott, you were sort of nodding your head, seemed like you were.
Yeah.
But my understanding is that there are certain misdemeanors, primarily misdemeanors, where there's basically no bail, right? And then as soon as you're arrested, you're booked and then released.
Oftentimes you're not even booked. You're just cited out in the field and released.
Oh, in the field.
Mm-hmm. So the
Okay.
officers will make contact with the individuals, cite them. If it's one of the qualifying charges that they can cite them, it's mainly misdemeanors. I do think that's something that could be improved by the penal code if we expanded it to more low-level, non-serious, non-violent felonies. We would have a whole lot more cite and releases happening. and less people booked in custody.
What are examples of non-serious, non-violent crime?
Vandalism, receiving stolen property, theft. I'm trying to think of some other ones. Mr. Cousins, what comes to your mind?
Stalking, bringing explosives on a plane. Yes, unfortunately there's plenty of felonies that are non-serious and non-violent that are still, pretty serious, but
No, of course, but the ones
Possession
that,
of ammunition, possession
Yes.
of a gun. I mean, you can have an individual stopped with probable cause for like speeding, and then they have a gun underneath their passenger seat, not being used as part of a crime, and then they're booked on having the gun in the passenger seat.
right. But still, there are non-serious, non-violent felonies, for example, the other one, drug, I guess that. these
All
are-
the drug stuff.
Right.
Yeah.
All right. And this is by statute, or then there are certain exceptions. Tom, maybe you want to jump in here, explain cite and release a little bit?
Sure. I mean, I think I don't have much to add, but there are, even for the offenses that are eligible, which are limited to misdemeanor offenses, there's specific offenses that are excluded, and then there's I don't know, maybe a dozen exceptions where the officer does not have to cite and release, and some of them are pretty broad, like a conclusion that the activity will resume if the person isn't arrested, or other things like that, I think make a lot of sense, but also have the effect of granting a lot of discretion to officers in the field.
And these are all given to discretions to arresting police officers. This is nothing that's happening in the police station. Is that correct?
Correct.
I think it's the penal, as far as the penal code goes, I think it gives some discretion about whether it can be in the field or after, the taking names and fingerprints and some minor booking happens. And it probably depends upon the police department and varies a lot. But I think there is discretion to sort of release after sort of, those initial booking procedures, probably at a police station. But I imagine it varies a lot. And of course, on top of this, there are consent decrees in a number of jails that give sheriffs further ability to essentially release people once they get to the jail, and they don't have to follow the rules in the penal code necessarily. So that's why you do see some cite and releases done in felony cases using that terminology that otherwise should be limited to misdemeanors.
And the same idea of the site release, another way to reduce jail population significantly is to give your arresting officers more flexibility or control to deal with warrants. So many of the bookings in custody are a result of warrants that could have easily been a cite and release, but for the nature of the warrant, the officers don't have a choice, any other choice but to book them into custody. And if you start looking at the jail populations and how many of the bookings are warrant related, it's crazy. I think
Well,
Sac
but
County
that's-
was 40%. We looked at for a year, 40% of all bookings was warrant related.
I mean, but that is something that a judge has reviewed and signed off on, like issuing the warrant. So, I mean, you're kind of supplanting the discretion of the officer in the place of the judge in that case. That would be my comment. And as far as this expanding the cite and release, I could see some room for that too. Definitely. The concern that I would have is, there are plenty of crimes that, we refer to as quality of life crimes that are expanding into things like theft and that sort of thing. And if somebody is truly just stealing all day long, every day, and all they're doing is getting a citation, that's kind of been a complaint from, retailers across the state, is if they do ever call the police on people that are coming in ransacking their stores, is that they get a ticket and are sent on their way. It could be exacerbating that problem.
Sure. I just want to say that the president of the California Retailer Association did come before our committee last year, and she, conceded that they don't really have data on whether or not these crimes are going up or down. And also is a big supporter of alternatives to incarceration. So I do think that we should reach back out to them to the extent that that could be a concern. Does anybody else?
And I would add on that is exactly why there's an exception in the law for conduct that's, the officer feels it's going to recur. So if an officer is not making an arrest there, it's not because they can't, it's more of a policy decision. And I think that sometimes gets left out of the conversation, especially around theft, which as you've said, Mike, we've addressed many times.
Any last questions for committee members, staff?
We have this great panel here, and I would love to hear, if it's possible, maybe from Jeff Clayton and Gina Clayton Johnson too, just about how the committee might think about preventative detention and what role it might have. These times when it's appropriate for a judge to conclude we're never letting this person out because we've deemed them too dangerous or something similar. There was a lot of discussion about that earlier, but I think it'd be great to hear from some of the folks here about it as well.
Well, I mean, I'd be glad to kick it off. I mean, obviously, I've criticized Section 28 of the Constitution and the interpretation that, you can detain anybody. I don't think that using the dangerous standard is appropriate. And when one of the judges said, the dream of RFK is dead, it's because of dangerousness. It's because we got into the future predicting business altogether. And if you look back through time, we generally never had that. And that was a no-no. But, we could always look at what the prior criminal record was, which I guess was always what the judges in New York said was the back door. But, for my money, I don't think we need it. I'm not convinced it's going away because you'd have to amend, Section 12 of Article 1. But I think we need to continue to support the right to bail by sufficient sureties, which is the language that appears in the California Constitution. And anytime we try to legitimize detention, we get away from what the Constitution says, which is sufficient sureties. That's what we're doing. We're setting an amount of security we think is appropriate. That's what we're doing. We're not detaining or releasing. To me, better fidelity to that provision is important. I know, and it's Justice Thurgood Marshall, said it's about the shortcuts we take to convict the guilty that harm the innocent, and that's exactly what detention does. So, we've also advocated for the ABA standard for differential case management, because the reality is that, like in Michigan, I don't know what the number is in California, 82% of jail costs are driven by 18% of defendants in the pretrial context, right? Those are the people that stay forever. So if we are going to do detention, why are we letting them sit there that long? So the bottom line is on all of this, I think, is just due process. We have to speed this up. We have to invest in the criminal justice system. And who wants to do that? Who wants to say we need to pour more money into prosecutors? We got to pour more money into judges. We got to pour more money into public defenders. But the reality is we do. We're just not doing a good enough job. And I'm sorry. And I would advocate for funding for all of the branches of government to do a better job on this. But, we stand against preventative detention. I've led a national movement against it, which I'm going to continue on. And despite the fact that, the bails would be lower on a non-dangerousness situation, if you don't like sub rosa detention, that's your answer. And that's how we got here. So that's my position. And that may not, I certainly don't speak for the whole bail industry on that. And obviously in other states like Ohio, there's movement to add that. But for my money, I've never seen any evidence that it's worth it and that we can accurately predict. And I just, to a constitutional degree of certainty. So I'll leave it there.
Building off of what Jeff Clayton said, we really didn't see public safety as a factor until the Bail Reform Act of 1984. And that coincided with the war of drugs. When you just look at history, that's when we start talking about bail having something to do with public safety. If we start reimagining public safety to not equal law enforcement, but public safety through a public health lens, then you can start dealing with that 18% of the jail population being the repeat offenders and everybody else not cycling through. Needs aren't being met at a state level, which is why we continue to see this revolving door at the jail.
And Chair Romano, if I may, think where you see the sweet spot in between bail and preventative detention and a judicial decision to hold somebody in custody is where pretrial programs and monitoring come into play. And that should be a large area because it offers an excellent alternative to custody. And especially for individuals who don't have the fiscal means to put bail forward.
That makes sense. Tom, did your last question go to Ms. Clayton Johnson?
That's just what I was going to say. I don't know if you have anything to add.
Yes, thank you. So we are aligned with really wanting to see clarification in the Article 1, Section 12 description of this. And I think that there's been a lot of really good briefing that has been done by Civil Rights Corps and Vera and others that we partner with on this. But in my conversation yesterday with this group of women, there was one woman who was a victim when she was 9 months old, having her mother murdered. And I'm getting some echoing, I'm not sure why. And I asked her, the hard questions about how she felt thinking about pretrial reforms that look liberatory and that are really considering the liberty interests and the presumption of innocence, kind of constitutional protections of a charged person. And her response was one that I actually have heard over and over again by by the women that we organized, who are victims, who are actually much more the center of vulnerability in our society as low income, Black and brown women in these communities. And she said, I'm completely in favor of that person being released because I see them as being someone who needs to be, what did she say? She said that it is their isolation and that it is the fact that they have not received services, essentially, that is creating problems and risk. And I was shocked, to hear that, because so often I think there's a public narrative, and I think the media is really getting a lot wrong in kind of what we can do and how directly impacted folks really feel. But what others have said is exactly right, that there is a problem with the funding and the prioritization of non-punitive community-based organizations to do this work. And that is no slight to the efforts of probation. I just know from my experience that community members do not see the Office of Probation as an office that is invested in their long-term needs, stability, health, and well-being. And at the end of the day, it's those things and having that relationship that keeps people on the right path. And we know it's obvious that that is true. And so I feel very much that, keeping in mind when we think about preventative detention, just when that it actually does not need it. We are creating the necessity and the crisis because of our funding patterns and because of the prioritization of punitive agencies and systems rather than putting our resources in places that make much more sense.
Thank you. Thank you all. This is another great panel. I learned a lot. I hope everybody else did. Some of you we've seen before. Thank you for joining us again. And I'm sure we'll be in touch. Please be in touch with us if you have reflections that might be helpful to us as we make our recommendations. Thank you all.
Thank you.
I want to take a 5-minute break before moving on to our next panel. So let's reconvene at 3:30.